In the midst of the civil rights movement, Chapel Hill, North Carolina, was considered the enlightened community of the civil rights movement, a college town with traditional Southern values and a hospitality that welcomed change. However, this illusion of enlightenment was shattered when civil rights protests came to Chapel Hill in the 1960s. The focus of the nonviolent protests were the more than 25% of Chapel Hill establishments that remained segregated. In January 1963, Dr. Peter Klopfer, a Duke University professor of zoology, participated in a civil rights protest that would spark a Supreme Court battle that would become a landmark in the nationalization of the Bill of Rights. In 1791, the Bill of Rights was ratified as part of the U.S. Constitution to protect the basic rights of all American citizens and to prevent tyranny by the central government. While this document would go down in history as one of the most ingenious protections of all time, it had one significant flaw which would take almost 200 years to fix.
What the First Amendment says is Congress may not abridge freedom of press, freedom of speech, expression of religion. It says nothing about the states.
In 1925, the case of Gitlow versus New York, the Supreme Court of the United States would, for the first time, conclude that freedom of speech and press guaranteed by the First Amendment was a right that must be abided by the state level. On January 3, 1964, Klopfer, along with 8 fellow professors and several African-American students, arrived at Watts Motel and Grill, a small local dining and motel establishment that refused to serve African Americans.
We were quite naive, and our intention, I might say parenthetically, was simply to present ourselves and explain that we would continue to patronize the establishment even if they let blacks into the lunch counter. Information that we were not privy to was that the proprietor was a very active leading member of the local KKK. As we got out of the car, we were immediately set upon by the staff of the hotel, who dragged us to the ground and began beating us. They had a hose with water coming out of it. It was a very cold, sub-freezing January night, so they doused us with water. They went from one to the other of us. We were at this point all flat on the ground, shielding our heads from broom handles that were being used to beat us.
Dr. Klopfer and his colleagues were arrested, jailed, and charged with trespassing, assault, aggravated assault, and conspiracy. On March 12th of 1964, Klopfer's case was called for trial, and Klopfer took the stand at his own defense. The prosecutor for Orange County decided to try each of the Watts Diner defendants individually in an attempt to make an example of them. After deliberating for 2 days, the jury was unable to agree upon a verdict and ordered a mistrial. Instead of retrying Klopfer's case later in the special session, the prosecutor chose to delay the case until later that year, which unintentionally mired the case in a significant national legal development. On July 2nd, not 3 months since Klopfer's declared mistrial, President Johnson signed into law the Civil Rights Act that banned segregation on the grounds of race, religion, or national origin in all public establishments. Furthermore, Title II of the law prohibited any attempt to punish a person seeking to exercise the right or privilege of equality. In December of 1964, the majority opinion of the Supreme Court in Ham versus the City of Rock Hill sustained the constitutionality of Title II public accommodation provision and required the states to apply the law retroactively. Klopfer and his attorney, Wade Penny, were encouraged by these developments and thought the state of North Carolina would drop the charges against him. But in August 1965, the solicitor of the Orange County Supreme Court of North Carolina entered a declaration of nolle pros with leave in Klopfer's case, a practice that was only used in North Carolina. Nolle pros translates to not to be prosecuted, and the with leave overrides the statute of limitations for a crime so that the prosecutor can postpone a trial for an indefinite amount of time while still holding charges against the defendant.
The prosecutor used it to keep me on the trial docket, which meant that every time court was in session, he could list me on the docket, which required me to come to court and sit there the entire day. But by virtue of the fact that he never called me to trial, I couldn't have the case dismissed.
The existing no pros with leave declaration was used as a way to quell civil rights protests. Hundreds of defendants throughout the state were intentionally intimidated and forbidden by local courts from participating in legal, nonviolent protests for fear of prosecution by the state. Wade Penny then appealed Klopfer's case to the North Carolina Superior Court and was rejected. Penny then appealed to the North Carolina Supreme Court, who voted unanimously against Klopfer.
It was not a long opinion that they wrote, but they made the baffling statement that even though we acknowledge that a person has a right to a speedy trial, we do not conclude that you have a right to make the state try you.
Penny then filed a writ of certiorari, a petition for the Supreme Court of the United States to hear their case. Since 1953, the Warren Court was known to select cases that helped to nationalize the Bill of Rights. By 1947, the previous Supreme Courts had already recognized that all of the First Amendment rights, including freedom of speech, press, religion, protest, and assembly, were fundamental rights that the states had to abide by. However, the Fourth, Fifth, Sixth, and Eighth Amendments were considered formal rights because they dealt with the rights given to defendants. The justices of the Warren Court embarked on a process of selective incorporation by analyzing each provision of the Bill of Rights to see if it was essential to fundamental fairness through cases such as Gideon v. Wainwright, 1963, which required the states to provide an attorney if a defendant cannot afford one under the Sixth Amendment. Mapp v. Ohio, 1961, which stated that the state cannot use evidence that was not obtained legally under the Fourth Amendment. And Miranda v. Arizona, 1966, which required the states to tell defendants their rights under the Fifth Amendment.
The Warren Court, year by year, keeps expanding the range until almost everything in the Bill of Rights is incorporated in the 14th Amendment. And it's at that point that we get Klopfer.
On December 8, 1966, Klopfer's case was argued in front of the Supreme Court.
I was only 30 years old, just 6 years out of law school. And although I had appeared before the North Carolina Supreme Court probably 5 times on oral argument, there's still nothing quite like walking up those marble steps.
The Supreme Court ruled unanimously in favor of Klopfer, with Chief Justice Warren writing, "Declaring that the Sixth Amendment does not apply to the states can no longer be regarded as a law. We hold that the petitioner was entitled to be tried in accordance with the protection of the confrontation guarantee of the Sixth Amendment." The Supreme Court, with its ruling, established that all defendants in any state had the right to a speedy trial. Its decision would later become the legal cornerstone for the Speedy Trial Act of 1974. While the outcome of the case was a personal triumph for Klopfer, it was also triumphant in guaranteeing the right to a speedy trial for all American citizens, as well as putting an end to the tragic abuse of no pros with leave. While no pros with leave was limited to North Carolina, had the Supreme Court ruled against Klopfer, this unjust legal practice would have greenlighted its use and spread to other states. No pros with leave had the potential to be a powerful tool to suppress freedom of speech and intimidate protesters during the civil rights movements. Through the 1960s, against the backdrop of civil unrest created by the civil rights movement, the Warren Court utilized the power of the judicial branch to incorporate all of the Bill of Rights to the state levels using strategic constitutional cases, including Klopfer v. North Carolina, to ensure equal protection under the law for all Americans. Not since Franklin D. Roosevelt's comprehensive domestic policy, known as the New Deal, has any one branch of government provided so many protections to the American people as did the U.S. Supreme Court in the era after World War II. While the executive branch in the 1930s safeguarded the nation from the harsh consequences of the Great Depression, the Warren Court protected the American people by nationalizing the rights identified in the Bill of Rights. What started as one man's desire for social equality in his small southern town ended with the Supreme Court ruling that every American was entitled to the fundamental fairness of the right to a speedy trial.